thank counsel for their flexibility. Our next case is Farm Bureau versus Lanier Law Group et al. And I'll note that Justice Dietz is recused on this case. We'll hear from the appellant.
Chief Justice Newby, Associate Justices of the Supreme Court, good afternoon. My name is Rick Pinto. Along with Matt Millhiser, I represent Lanier Law Group and Lisa Lanier. And for purposes of this argument, I will just refer to that group as Lanier. I'd like to reserve 7 minutes for rebuttal time. Let me tell you 2 things I am not going to do to start out. First, I am not going to recite the underlying facts of the underlying case or this case. You have read 6 briefs, not just 3, and a Court of Appeals opinion, all 7 of which have outlined the facts underlying the case. I also will skip that portion because this is not a fact-specific or even important case. This is a case where you are only going to look at an amended complaint, an insurance policy, and determine whether or not there is coverage and a duty to defend that underlying lawsuit. I think the parties agree on all of the facts. Perhaps most of them we'll hear. A second thing I'm not going to do, I'm not going to be critical of North Carolina Farm Bureau. North Carolina Farm Bureau is an excellent North Carolina grown insurance company. They did initially what they should have done in this case. When Lanier was presented with this underlying Gary versus Lanier and 10 or 15 other plaintiffs' law firms in our state back in 2016, I believe, they handed it over to North Carolina Farm Bureau for a defense, and Farm Bureau said, we're not so sure about that, but we will defend you. And they did defend Lanier up until the point in time that Judge Bray granted summary judgment on cross motions for summary judgment at the trial court level in favor of Farm Bureau, determining that there was no coverage for this event and for that lawsuit. At that point, Lanier was on its own, had to pay for their own counsel to defend the case because Farm Bureau pulled that defense at that time. It's not a bad faith case. We're not saying Farm Bureau did anything that would warrant bad faith. What we're saying is that they should have continued to defend, and in fact there was coverage under their lawsuit, for the lawsuit under their excess CGL policy, at least. You may have noticed that there are a number of policies that Ms. Lanier and her law firm had with Farm Bureau. The only one we need to talk about today is the commercial CGL excess policy. And the reason is that that is the policy where coverage is most obvious. Put another way, if there's not coverage under that policy, there's not going to be coverage under the other policies, so there's no need to take a look at them. We're here because this court granted our petition for discretionary review based or from an opinion of the North Carolina Court of Appeals, where Judge Dietz sat. The Court of Appeals ruled that there was no coverage because one specific exclusion in the excess policy applied, and that is the exclusion for willful violation of a penal statute. Farm Bureau filed a conditional petition asking the court to consider 2 additional items. One, whether there was, it was appropriate to have an initial grant of coverage under the insuring agreement under that same policy. And second, whether a second exclusion would have applied, the professional liability exclusion. So what I want to do is take those three very pointed issues and talk about them. I want to talk about them in an order that sort of made sense to me. That is, initially about the grant of coverage, because if you don't have a grant of coverage, there's no need to look to exclusions. And then if the court finds that the coverage was appropriately granted, whether one or the other or both of those exclusions apply. As a bit of background, the underlying DPPA litigation, it was a Driver's Privacy Protection Act. It's a federal statute, and 2 lawsuits in North Carolina were filed against, I believe, 15 different law firms, alleging that their direct mail solicitation activities trying to get clients violated that federal act. That was filed before in the Middle District of North Carolina. Judge Biggs was the judge assigned to it, and she ultimately granted summary judgment for the defendant plaintiff law firms, the defendant law firms who were plaintiffs' law firms. The Fourth Circuit affirmed that summary judgment. So the case is over, in fact, over by several years at this point. As I read the rationale for that case, the court, Judge Biggs and the Fourth Circuit, had to assume that all of the law firms, including Lanier, knowingly obtained, disclosed, and used personal information that they got from an accident report. So because it was at summary judgment, they had to take those allegations as true, which they did. Those were disputed to some degree, but not really. And they said with that, summary judgment should still be entered for the defendant. The rationale was kind of narrow, that a motor vehicle accident report is not technically, under the DPPA, a Department of Motor Vehicle record. And so that's how that case ended. Okay. Going to the first issue, which is an issue under the conditional discretionary review. Do the allegations in the amended complaint in the Gary case trigger the insuring agreement under the policy? The answer is yes, they do. I'll start with something that's less important. I believe that you can infer from the Court of Appeals opinion that they found there was coverage initially subject to exclusions. I say that even though the word coverage and insuring agreement can't be found anywhere in the Court of Appeals opinion. I suggest that they determined that there was coverage because, frankly, without finding an insuring agreement that gives coverage, there's no reason to look at exclusions. If they didn't believe there was coverage, they could have said so. But again, that's not something that I think this court is going to be bound by. More importantly, the insuring agreement, and particularly coverage B, advertising injury under the excess policy, provides coverage for oral or written publication of material that violates a person's right of privacy. That is found under coverage B. You'll see a list of, I didn't count them up, but 5, 6, 7 claims that are covered under the advertising injury section of the policy. They are claims like assault and battery and slander and libel and some other tort-like claims, not all. But listed in there is this claim for oral or written publication of material that violates a person's right to privacy. That coverage needs to be read broadly. A canon of insurance policy construction says you have to read broadly if you can to provide coverage. You read narrowly if you are going to apply an exclusion. So whatever you're looking at, you're trying to do what you can to find coverage to the policyholder and against the writer of the policy, the insurance company. What Farm Bureau has argued in their briefings is that the DPPA is not a listed claim under Section B of the policy. And because it's not a listed claim, there should be no grant of coverage. The only thing that was granted is this more broad oral or written publication of material that violates a person's right of privacy. And they say because it's listed there with other tort claims and other common law claims, that should be limited to just common law right of privacy violations or the tort of invasion of privacy, the right of privacy. You can't have a more narrow view of it than that, and of course this court is not supposed to take a narrow view of an exclusion that would bar coverage. What they could have done is say, we will only cover common law violation of rights of privacy. They could have put that in there, and then we wouldn't be here today. They could have said, we are only covering torts, and here are the 4 torts that we're going to cover, or 5 torts that we're going to cover. They didn't do that. I think maybe the North Carolina Farm Bureau versus Pascal case says it best, where they said the insurance company chose the words, right? The words should be construed against the drafter. They should be interpreted broadly to provide coverage. And if their words provide more coverage than the insurance company intended, fault lies in its own selection of words by which it chose to be bound. In other words, they wrote it, you have to interpret it broadly. And
before we get to the phrase person's right of privacy, we have the word publication. Yep. Can you address the argument that the conduct alleged in the Gary case didn't amount to publication?
I can and will. Thank you. There is the argument from Farm Bureau that there was no publication here. First, for 4 reasons, there absolutely was publication. And this is, again, something that needs to be construed broadly so as to benefit the policyholder and provide coverage. So with that, that's the view that this court needs to take a look at. First, the Prime TV case that's set forth in our brief was a very, very similar case. That was a case where a company was faxing advertising material to folks, the people that they wanted to, the claimants in the case. And they determined that that action, in fact, was a violation of a privacy claim, which encompassed publication. You had to have publication. Now, they didn't go into a publication analysis, but they could not have come to their conclusion if they did not believe that faxing one single page to their intended potential clients or claimants was a publication. Second, I started out the argument by saying you need to compare the amended complaint with the policy. The amended complaint in this case alleged that the defendant law firms on printed envelopes with stamped, this is an advertisement for legal services on them, and with the name and address of the proposed claimants or plaintiffs on them were prepared. They were seen by office workers, they were seen by contractors, they were seen by post office employees, and they were seen by the recipients of the letters. So it was published to all of those folks. Additionally, inside those envelopes, once they were opened, was an accident report. The accident report showed the name and address not only of the prospective plaintiffs or claimants, but also of everyone else involved in the accident. Also, the owners of the vehicles, also passengers in the vehicles. So that information was shared with everyone. All of that shows publication. Next, the amended complaint alleges that Lanier knowingly disclosed that information. Disclosing information is the same as publishing information. If you're not publishing it, how can you disclose something if you're not publishing it? That is merely giving it to someone. The argument from Farm Bureau is you only gave it to the person whose name was on it, so that's really not a publication. One, that's contrary to Prime TV case, because that's exactly what they did, but two, it's all those other folks, and all of that information is contained in the amended complaint. Thank you. That's why there should be coverage in the case. With regard to the first exclusion, willful violation of a penal statute. The Court of Appeals opinion, Judge Tyson's authored opinion, relied solely on that one exclusion to deny coverage. What they did was they said, knowing and willful, the two words that were at play, we looked them up in the dictionary, and their definitions looked pretty similar. So we're going to treat them as the same. And so when we look at knowingly obtaining, disclosing, and using personal information, which is the wording used in the DPPA statute, we are going to say that that is the same thing as willfully violating the DPPA. And I would suggest to this court that that is an oversimplification. It is broadly, well, it is very narrowly construing that statute as opposed to try and deny coverage, as opposed to broadly construing it to grant coverage. And it violates, it contradicts cases from this court and the Court of Appeals, and for other reasons. I'll start with what cases is different. The Court of Appeals could have looked to case law to see what the cases say about knowing and willful. They did not do that. If they had done that, they could have looked at the State versus Stevenson, State versus Ramos, State versus Couture case, all of which are in our brief. They're all three of those were criminal cases, but they all stand for the same thing. That is, there is a difference, a legal difference between knowing and willful, doing something knowingly and willfully. The Stevenson case, the court said, willfully is more than knowingly. It is a higher standard. The Ramos case was a case where someone deleted some information off a computer. There was a statute that did not allow that. That was a violation. But they said, but they thought they were authorized to take that information off of the computer. And the court went on to say, even though that was a knowing act, taking the information, they did not willfully violate the statute because they thought they had authority to do it. The Scaturo case, same thing. Someone was involved in an accident, and he left the scene. There's a statute that says you can't leave the scene. That's a violation of a criminal statute. He said he left the scene to try and get help for the people who were injured, so for a good purpose. Again, the court said the action was knowing. He knew he was leaving the scene, but it was not a willful violation of that statute. So there is a very big difference between those two words that the Court of Appeals frankly ignored. On the civil side, and analogous, the Farm Bureau case against Stocks. That was a case where a couple of guys who were employees got into a tussle. One of them pushes the other, falls down, he gets injured. Farm Bureau, in their policy, says no coverage because of the expected or intended injury exclusion. Said, he meant to push him, so no coverage. And this court said no. Why the action itself was intended, the injury was not intended, and therefore the exclusion doesn't apply. Here, Lanier is alleged to have intended to obtain, disclose, or use personal information from accident reports. If you forget anything that I say when I'm up here today, please remember this. Nowhere in the amended complaint does it state that Lanier willfully violated the DPPA. That allegation is not in the complaint. There are a number of allegations that are in the briefing on both sides where they are alleged to have knowingly done some things, but it's always knowingly obtained, disclosed, or used the information, much like the actions in all of those cases that I just shared with you. But you have to have both. There have to, for this penal statute exclusion to apply, you have to know the act and you have to willfully violate the act. So that's the first reason.
Put another way, if I'm doing the comparison test that I think we're required to do under the waste case in Harleysville, right. In the exclusion, Farm Bureau wrote that it's a willful violation. So that adjective is right connected with the violation part, whereas in paragraph 46 in the complaint, it's knowingly obtained, disclosed, and whatever, and then blah, 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 in violation. So that placement of that clause or the space between it seemed significant to me doing the comparison test. Is that what you're saying, just in a different way?
I think it is. I think it is. They chose willfully, and I'm going to show you a couple, assuming time allows, other policies from other cases that arise out of the Gary case with other law firms who had a different exclusion that was appropriate. And those exclusions talk about violating statutes, federal or state statutes, and they exclude them from coverage. And the Fourth Circuit in all of those cases said that's correct. The difference in this case is Farm Bureau chose to make that a willful violation as opposed to just a violation. But for that word, we would not be here either. So in this case, it is certainly possible that Lanier could have knowingly used, obtained, or disclosed that information and not have violated the statute. In fact, we know that's what happened, right? That's what the court said in the Fourth Circuit affirmed. They also could have knowingly used, disclosed, and obtained the information. They could have been found civilly liable under the statute without being found to have willfully violated the statute. The Pilcher case, which is a Third Circuit case, talking about the DPPA, said Congress differentiated between a knowing acquisition, disclosure, or use and any knowing violation of the statute itself to establish a crime. So they're recognizing that there's a distinction in the DPPA. Here, whether or not there was a violation, we know now that there wasn't, but even if they determined it was a violation, it didn't have to be a willful violation. You still could have been found liable. The statute itself makes a distinction. If you look at the statute, the first section of the statute says, you have violated the statute and subject yourself to actual damages and liquidated damages if you have done any of those things. And then underneath that, it says, if this violation is willful, then you can be subject to punitive damages. So the statute itself says you don't have to willfully do anything to violate the statute. Again, there are no allegations in the complaint of willful actions. The Aetna versus Sunshine Corporation case, which is a Sixth Circuit case, looked at this exact penal statute, this exact same statute, and they were looking at whether there was a violation of the FCRA. I'm not really sure what that act was. But what the court said is that if an insured could be liable for a non-willful violation, then this very exclusion does not apply. The only way it would apply is if there was no other way to be liable under the statute other than a willful violation. And last, Farm Bureau could have just taken the word willful out of their exclusion, and that would have solved the problem. Or they could have written in the same exclusion that Nationwide and Hartford and others wrote in their policies, which says we exclude any claim that arises out of the violation of a person's right of privacy created by statute. That's what the other insurance companies' exclusions, how they read. Okay, let me quickly, I know I'm running over, I think, my time, if I can read that correctly. On the professional liability exclusion, the Duke University case was a case where St. Paul, what happened is someone forgot to lock some casters on a dialysis chair. When the chair moved, person fell, person was injured. Duke University Hospital was sued. St. Paul said, no, professional liability exclusion applies, no coverage. And the court said, no, in that exclusion only applies for those services where professional training is a prerequisite. Failing to lock casters on a dialysis chair you don't have to be a doctor to do that, so it doesn't apply. Here, three things Lanier was accused of doing: obtaining the accident reports, disclosing the information, using the information. All of that was done by staff members. You don't have to have a law degree or any training to get motor vehicle records. You don't have to have that training to mail them out. You don't even have to have that training to go from one to the other. Farm Bureau's argument is someone had to decide maybe who was at fault and who might be a plaintiff and who might be a defendant, and that has some kind of legal training. I would submit, no, it doesn't. First, the folks, on the accident report itself, it shows who got a citation or who had contributing factors, so all you have to do is look at the accident report and you can figure that out. Second, Farm Bureau adjusters every single day look at accident reports and come to those same conclusions, whether their people are at fault or not at fault. So you don't have to have a law degree to do any of that. At least some, certainly obtaining it, you don't need to have that. And if any of those activities fall outside the exclusion, then that exclusion should be barred, and it is not applicable here. I reserve the rest of my time. Thank you.
Thank you, counsel. We'll hear from appellant.
Good afternoon, Chief Justice Newby, Associate Justices. My name is David Brown. I'm here along with my partner and wife, Martha Brown, here. We have the privilege and pleasure of representing North Carolina Farm Bureau in this case. I appreciate the opportunity to be here this afternoon. I want to start, well, first of all, with regard to my friend Mr. Pinto's kind of basic recitation of what happened in the underlying case. I agree with that. That's true. Other than this, Farm Bureau actually defended, and the record shows this, with two law firms. Farm Bureau hired separate counsel for Lanier, and Lanier also wanted to participate jointly with the other law firm defendants, and Farm Bureau paid a pro rata share of that, and did so up through not the trial court ruling in favor of Farm Bureau, but the Court of Appeals ruling in favor of Farm Bureau in June of 2021. A year later, in June of 2022, the Fourth Circuit affirmed Judge Biggs that there was no summary judgment in favor of all the law firm defendants in that underlying case. So the duty to indemnify never arose because there was no judgment against Lanier to be indemnified. And the duty to defend that we're talking about here is really the duty to defend between June of 2021 and June of 2022. The Court of Appeals correctly noted Farm Bureau is not seeking recoupment for any of the money that it paid in defense cost. Whether or not that's allowed under North Carolina law, perhaps Your Honors will get to consider that another day, but that's not in this case. And so that's kind of the scope of what we're talking about. Maybe not a lot in dollars, but extraordinarily important legal principles, which brings us all here today. And I want to start with this legal principle, and that is a discussion of the duty to defend standard. I didn't hear Lanier's counsel mention the duty to defend standard at all, but what caught my eye was in their brief, Lanier takes the position that the duty to defend standard this court should adopt is that there's a duty to defend if there is a mere possibility of coverage. And respectfully, that standard has been overruled and denied by this court in a unanimous opinion written by Justice Newby in the Hardeesville versus Buzzoff case. And just a quick walk down memory lane, maybe for people like me that deal with duty to defend issues every day for a living. The waste management case in 1986 did articulate the standard. Justice Riggs is correct, the comparison test standard. Between 1986 and 2010, there have been some intermediate Court of Appeals cases that had gotten into this language about, well, maybe if there's just a possibility of coverage, which is not what waste management said. Waste management said that there's a duty to defend only if there's a covered claim on which the insured may possibly be liable. So the possibility referred to the insured's potential liability. Were they at fault or not for the car wreck? Were they at fault or not for violating the DPPA? Not to coverage. There's no such thing as a possibility of coverage. That issue came back up squarely before this court in the Hardeesville versus Buzzoff case, which was a duty to defend coverage B CGL case. And again, in a unanimous opinion authored by Chief Justice Newby, then Associate Justice Newby, this court articulated very clearly what the standard was and flatly rejected the possibility standard and instead said, and I quote Justice Newby, in addressing the duty to defend, the question is not whether some interpretation of the facts could possibly bring the injury within the coverage provided by the policy. The question is, assuming the facts as alleged to be true, whether the insurance policy covers that injury. So that's the standard. And the Court of Appeals subsequently, in the Kubik case and others, recognized that the Hardeeville versus Buzzoff opinion from this court overruled Crandall and some of the other cases from the Court of Appeals that had in the interim adopted the standard that Lanier now urges back on the court. So if nothing else, I would respectfully submit that standard, the Hardeeville versus Buzzoff standard, has served policyholders and insurers very well for the last 14 years in North Carolina. And I would respectfully say that this court should follow that standard and not go back to an intermediate Court of Appeals standard, which is contrary to both this court's opinion in waste management and this court's opinion in Hardeeville versus Buzzoff. Now, I go down that path because it's an important one, because frankly, I think getting the duty to defend standard right in this case is case dispositive, which may be why Lanier urges a different standard. So why do I say that? Well, we're talking about CGL coverage B, and I'll start with this. You know, no case has ever found CGL coverage for violation of the DPPA. No case in North Carolina, and there have been several federal court opinions that have addressed it. No Fourth Circuit case. There have been cases from other jurisdictions. Nobody has found coverage for the DPPA for different reasons. Some have found it doesn't trigger the insuring agreement. Other courts have found that an exclusion applies, such as the trial court and the Court of Appeals here in this case did as well. And why is that? It's because coverage B is a limited scope of coverage. In the CGL policy, coverage A is broad coverage. It's any bodily injury or property damage caused by an occurrence, right? That's not what we have here. Coverage A for bodily injury and property damage claims is broad coverage. It doesn't really matter what the claim for relief is. It matters, is there an allegation of bodily injury or property damage, and was that caused by an accident, i.e. an occurrence? Coverage B is quite different. Coverage B is coverage for enumerated offenses only, meaning that the coverage only applies if one of the offenses listed in coverage B of the policy is a claim for relief against the insured. That has been, very clear from this court going back to the Henderson case in 1997 from Justice Parker. That was a case where the insured was liable for a Chapter 75 violation for unfair and deceptive trade practices. The insured in that case argued, well, a coverage B enumerated offense is unfair competition. That's a lot like unfair and deceptive trade practices. We should have coverage, and this court unanimously said no. It has to be an enumerated offense in order to trigger coverage. We cite in our brief the Russ case from the Court of Appeals, the Wakestone case from the Eastern District. There are other cases kind of applying and looking at North Carolina law that get to that point. So in this case, the inquiry is applying the duty to defend standard from the Hardeeville court. Is there an enumerated offense under coverage B for which the insured has been sued? And the answer is flatly no. No, because number one, the DPPA is not an enumerated offense. And I would respectfully suggest that's the end of the case. The DPPA carries with it, and what was sued for here and why these cases became such a big deal in North Carolina was liquidated damages of $2,500 per violation for hundreds of thousands of violations. So it adds up. That was the threat when the lawsuit first came along. That is not a risk that Farm Bureau assumed in ensuring enumerated offenses for publication of information that violates a person's right of privacy. So, I heard that maybe we were being a little too difficult by saying no DPPA violation, therefore no coverage. That's true. That is our position. We only cover enumerated offenses under the duty to defend standard, the comparison test, as articulated through this court in Buzzoff. But let's go further than that. Let's talk about, number one, invasion of privacy. Because invasion of privacy is an enumerated offense, oral or written publication of information, as Justice Allen correctly points out, that infringes upon a person's right of privacy. So I think the first, if you're going to go past that duty to defend standard and kind of adopt this, well, possibly, even though there was an enumerated offense sued over, maybe possibly somehow there might be some claim there that's covered, was there an invasion of privacy offense pled here? And the answer is no. And I'll get into that substantively, but the Fourth Circuit in the Hartford versus Ted Grieve and Associates opinion said very clearly, the lawsuit, the DPPA lawsuit, is the right that the defendant insurance companies or the defendant law firms are alleged to have invaded is the DPPA. They are not, that's the right protected by the statute, not by the common law of North Carolina. I'll try to be a little more clear. The common law of North Carolina does not recognize the invasion of privacy offense that was pled here against Lanier and these law firms. North Carolina recognizes two invasion of privacy offenses. The first one clearly doesn't apply here. It's commercial misappropriation of a name or likeness. The second one is the intrusion upon seclusion offense. That's the offense here that is being discussed. The cases in North Carolina that have found a violation or invasion of privacy based upon an intrusion upon seclusion have been physically invading someone's home, eavesdropping via wiretap, peering through their windows and going onto their property, unauthorized use of their bank account, and the like. As the Broughton case that we cited and others from this court and the North Carolina Court of Appeals have made very clear, there is no expectation of privacy in someone's name and address. We have to give that everywhere we go, to get on an airplane, to go into courthouses, to do different kinds of things. That is not the kind of intrusion upon seclusion offense that has been recognized as an invasion of privacy offense by North Carolina law. Now, so what are the allegations? I think we have to turn back to first principles and comparison test. Let's look very closely at what was alleged against Lanier and the defendants. And if we look at the first amended complaint, which is at record page 47 specifically, the complaint details facts related to obtaining and using personal information from motor vehicle records. So what are the facts? What are the invasion of privacy that is alleged, if you want to go down that path, by the complaint? Paragraph 65 says, within a few days of, an accident, the Lanier defendants obtained a copy of the DMV 349, obtained it. And then paragraph 88 of the complaint, references the underlying, the ad that was actually sent, but the complaint that alleges that the accident report was sent to the plaintiff. That's the alleged invasion of privacy, that the accident report was sent back to the person who was in the accident. That is not an intrusion upon seclusion. That is basically saying, if you get junk mail, if you get mail from an advertiser, if you get political mail, if you get mail from a house of worship asking you to come this weekend to worship, that somehow is invading your privacy if you didn't ask for that information. All that's happening here, all that's alleged when we look at the complaint, is that the accident report was sent back to the people who were in the accident. Nothing more.
Help me understand how we square that with the Prime TV conclusion that, sending a fax is an invasion of privacy.
Well, the Prime TV case found coverage under coverage A for property damage. They found that the paper that was at issue on your fax machine was somehow, you were deprived of the use of that. And so the coverage that was found in Prime TV was found under coverage A. I guess beyond that, Justice Earls, what I would say is that the idea here that you've intruded upon someone's seclusion by mailing a copy of an accident report to them from an accident that they were in is not something that can be squared with the law from this state that says that's a very narrow tort. So has that tort been sued over here? We would suggest no.
Well, but there is other information on the accident report as well, not including witnesses and passengers, and there's no guarantee that the person who was in the accident would necessarily be the person who opens the envelope at the home. I mean, it seems like you might not want everyone to know you had an accident, and there could be an invasion of privacy there.
Yeah, I understand your point. I guess I would respectfully say that the information about others who were in the accident or passengers in the vehicle, et cetera, would not be on the, I mean, this information is not going to them. It's going to whoever's been determined by the law firm to not be at fault in the accident and perhaps have a claim.
Right, so it would be those persons, right? So if I witness an accident and my name's on an accident report, and then that is sent to the person who was in the accident, the driver of the car, then that's the invasion of my privacy.
I agree with you, but the plaintiffs here are not the people who witnessed the accident. They're the people who were in the accident who are being solicited to be represented by these law firms. That's who the ad is going to. It's not going to the innocent bystanders who happen to witness this. And I guess I would just refer to, I'm sorry.
If you're done answering Justice Earle's question, but as I understand the purpose behind the DPPA, I mean, this is about people, I mean, you don't dispute that there's postal workers handling it, that other people in the household can be exposed to it. I mean, I think we have a civil rule that publication does encompass or anticipate that people see mailing outside, it's not just the person who was in the accident, it's the people in the household, it's the postal workers, and so for civil liability, that's publication.
For civil liability, would it be, well, I'm coming to the publication right now just on the invasion of privacy, but I agree with you that sometimes the concepts overlap. Were the individuals who were in the accident, who were there being solicited to file suit, was their privacy being invaded by the fact that a postal worker saw a letter come into their house with a law firm on it? I would respectfully suggest no. I don't think that's an invasion of their privacy to be getting a letter from a law firm. It could be about anything. It could be about a will. It could be about anything at all. There's no allegation that the postal officers were opening their mail and reading it, or somehow they were getting their personal information exposed that way.
I mean, if my husband got a letter from a law firm and I check our mail, I'd probably ask him about it. So, I mean, I think that's maybe an analogy for you.
Would that be, I guess, if your question is, would that be an invasion of your husband's privacy?
Of his privacy, published to me that something happened.
Yeah, I understand your point. I would respectfully say no. I don't see how that is an invasion of privacy if it's coming to him at his home, addressed to him, telling him something he already knows. I don't see how that somehow the law firm that sent it has invaded his privacy in some respect. And I would point to the Nationwide versus May case from Judge Whitney in the Western District, specifically found here that there were no allegations in the DPPA lawsuit that would support a violation of a recognized privacy right under North Carolina law. The same from Judge Biggs in the Main Street versus Crumley-Roberts case in the Middle District of North Carolina. Same from the Fourth Circuit in the Hartford versus Grieve case. I mean, there are several federal courts that have addressed very specifically this issue of is there even if you go down the path of saying, well, the DPPA is not a enumerated offense, but is there an invasion of privacy tort that is a seclusion violation under North Carolina law that has been pled against the insurer that have said, no, this invasion, the alleged invasion of privacy here is not something that's recognized as a matter of tort law under North Carolina law. And again, that's what the Fourth Circuit said, and I would respectfully, suggest that maybe that case involving Hartford and Grieve from the Fourth Circuit that I quoted from a moment ago would be pertinent as well. Now I want to turn to the issue of publication, which I agree are a little somehow the invasion of privacy, because even if we're down the path of saying if there's a possibility of coverage, you're going to find a duty to defend, or even though the DPPA was not sued over, we're going to look for this invasion of privacy offense. There still has to be publication of it, as Justice Allen correctly pointed out. There is oral or written publication of information. So was there oral or written publication of information? Again, I just kind of went through the complaint. What's alleged in terms of the relevant facts, the facts of what happened, are that Lanier obtained the DMV 349 and sent a copy of it back to the person who was in the accident. I would respectfully suggest that's not a publication at all. And significantly, in the Fourth Circuit opinion in the Gary versus Farron case from June of 2022, affirming summary judgment for the law firm defendants, the Fourth Circuit found that the only theory being pursued by the plaintiffs in the case was the obtaining. The Gary plaintiffs made clear that they were only pursuing a theory of obtaining the plaintiff's personal information. Under their theory of the case, the obtaining of their personal information is a fait accompli, meaning once individuals were in the car wreck, once a DM-349 was generated, the information was then obtained, that there was no claim for relief that was sought over any alleged publication, use, et cetera. So again, we get back to, and it's the reason I started with the duty to defend standard. What exactly were the defendants sued over? What exactly was Lanier sued over? And the lawsuit was not over anything other than the obtaining of the information, according to the Fourth Circuit. And even beyond that, merely sending it to them wouldn't necessarily be, I would respectfully suggest, any sort of publication that would then trigger coverage under the policy. So I kind of pause there. Our view, and I agree with my friend Mr. Pinto here, that the correct analysis is there any coverage under the insuring agreement at all? And then and only then does one turn to the exclusions. And respectfully here, if you apply the duty to defend standard from the Hardeeville Court, if you look at the Coverage B case law and what is found to be the scope of coverage under Coverage B, i.e. for enumerator defenses only, looking at Henderson, looking at Russ, Wakestone, that line of cases, the only conclusion is that the relief sought against the insured here was only over something that is not an enumerator defense. And then if you want to go down further down that path, then I think we get into the question of, well, even looking under the hood more, was there an invasion of privacy offense recognized under North Carolina common law that was pled? Again, the Fourth Circuit in the Grieve case has said, no, it was not. And then was there any publication? Was there any relief sought over anything other than merely obtaining the information? And again, the Fourth Circuit in the very Gary versus Farron case and Lanier and others that was from June of 2022, affirming summary judgment in their favor, found no. And it was critical to the holding, because what the Fourth Circuit found was that the only relief sought was over obtaining the information. And since what had been obtained was not anything that was a motor vehicle record, there had been no violation of the statute. So it wasn't just a kind of an idle comment. It was a critical comment to the holding in the case. So Farm Bureau would respectfully say that the insuring agreement was not triggered, and this court should find that there is no coverage because there was no coverage under the insuring agreement, on which the insured policyholder bears the burden of proof. I mean, that's kind of standard black letter law. The insured bears the burden of coming within the purview of the insuring agreement, and then the insurer bears the burden of proving the applicability of an exclusion if we're talking about exclusions. So the burden here on proving that there was an invasion of privacy offense, that there was a publication, that there was something here that would trigger coverage is on the policyholder, and then only if we turn to exclusions does the burden shift to Farm Bureau. So let's turn to exclusions, on which Farm Bureau would have the burden. As you know from the briefing and the discussion, there are two exclusions here. One is the one that the Court of Appeals based its opinion upon, the willful violation of a penal statute, and the second one is the professional services exclusion. So I'll take those in turn. First of all, with regard to the willful violation of a penal statute exclusion, a few things are crystal clear. Number one, the DPPA is a penal statute. Again, the Fourth Circuit opinion from June of 2022 in the Gary case, the underlying case, is a very fascinating read on just kind of the history of the DPPA. That's in some other cases as well, but the Fourth Circuit kind of summarizes the history of the DPPA and how it came into being as a criminal statute, and then only at the very end was a civil cause of action then added to the mix. So there's no question but that the kinds of violations that are alleged are penal in nature, meaning that this is a penal statute. Number two, every allegation that is made against the defendants in the underlying case is a knowing violation. That's undisputed. I agree, it doesn't say willful, it says knowing, but it's a penal statute, and every single thing that it is alleged that the defendants did, that it is alleged they did it knowingly. So then the question becomes, is a knowing violation, which is what's alleged, and applying the Hardeesville versus Buzzoff standard, what we have to go by, is that a violation of a willful violation of a penal statute? And it clearly is. There's some question about where does one look to get information. What this court has traditionally looked to is standard dictionary definitions to come up with how to interpret policy terms that don't have a specialized definition.
The problem with that, though, is that there's tons of case law interpreting willful in all kinds of contexts, including tort, for example. So is it proper for the Court of Appeals to rely on a dictionary definition when we have this universe of case law interpreting or construing those terms?
Absolutely, and I say that for this reason. I don't think the Court of Appeals ignored any of those cases. I think the Court of Appeals actually looked at those cases. A lot of those cases, as you point out, are criminal cases. Others are civil cases in various contexts. I don't think the Court of Appeals ignored, for example, any precedent from this court in an analogous civil case as to how willful should be interpreted. Any court, Court of Appeals, this court, any court has to get its bearings somewhere. And what the court relied upon, accurately so, I would contend, is that knowing and willful both are defined as taking deliberate action. So it's that definition, not only in the dictionaries, but in the cases of deliberate conduct that is knowing and deliberate conduct that is willful. And so you have a complaint that alleges that all the actions that violated a clearly penal statute are done with deliberateness, then that would fall within the ambit of that exclusion. In the last couple of minutes I have here, I'll turn to the professional...
I'm sorry.
I'm sorry, yes, sure, go ahead.
So doesn't the DPPA distinguish between knowing and willful violation?
It does not make that distinction. What it says is that punitive damages are available upon a willful violation of the law. In other words,
So in the way you're interpreting those terms, that would mean any violation of the law would give rise to punitive damages.
Yes. I think the distinction, as I understand the language that Congress used in that statute, one could violate the statute knowingly, that is, deliberately do the act that turns out to be in violation of the statute, deliberately, send information that's in violation, motor vehicle records that are in violation of the act, knowingly. Maybe you never even haven't heard of the DPPA, not knowing that that's a violation of the law, but nonetheless, if you did it and you undertook the actions deliberately, you violated the act. And for civil purposes, criminal purposes take their own course, but for civil purposes, that would not be covered under an insurance policy that has the exclusionary language that we're relying upon here. Later in the DPPA, what it says is that if one willfully violates the law, that is, you're aware of that it's out there, and you nonetheless proceed in flat violation of the law, knowing it's there, then you can be subject to punitive damages. And the complaint here against Lanier candidly alleges both. It alleges a knowing but unwitting violation, and then later, after the lawsuit was filed, in the first complaint, amended complaints say that Lanier continued to violate the statute and therefore should be, they never sued for punitive damages, but basically said, once we sued you and brought the DPPA to your attention, you should have stopped. But I would respectfully suggest, if I understand your question, that the knowing or deliberate act that violated the statute would be excluded by the exclusionary language we're talking about. The only distinction for willfulness would be later, if you continue to proceed in violation of the law, then the plaintiff could pursue punitive damages or not, as they deem fit. Finally, on the professional services exclusion, I just kind of make this note. The only case in the country that's ever actually found insurance coverage for a DPPA claim found it under professional liability policy. It's a case that we cited in our brief from the Southern District of New York. Found that the act of violating the DPPA, of doing exactly what the defendants are being accused of here, involved a professional service. So most law firms, like my law firm, will have a professional liability policy to cover us for professional activities that are improper, and then a general liability policy to cover us for the kinds of, property damage or bodily injury caused by an occurrence, or being sued for an enumerator defense under coverage B. Here, the only coverage that's ever been found in any case in the country, found it under professional liability policy, and I would respectfully suggest did that because they didn't send these DMV 349s to everyone who was in an accident. There was an assessment made of exactly who was at fault, how they were at fault. I'm not suggesting someone has to have a law degree to do that, but it does involve an element of professional training and analysis, which is exactly what the professional services exclusion speaks to. I see I'm at the red button. Thank you, Chief Justice Newby.
Thank you.
Court.
Yes, sir. Our rebuttal, please.
If it please the court, on that last point, I just refer you back to the Pilcher case. Basically said Congress differentiated in the DPPA between the knowing acquisition, disclosure, or use of the information and the knowing violation of the statute. So the cases have already addressed that point, and pretty clearly there are two standards under the DPPA. Next, with regard to the duty and what you should look at, I'm not exactly sure what Mr. Brown was referring to when he said that we were talking about the mere possibility of coverage. I'll quote from our brief on page 3. If a review of the pleadings in the underlying action give rise to even a mere possibility that the insured's potential liability is covered by the insurance policy, then the carrier has a duty to defend. That's the law, that's the waste management law, that's Harleysville versus Buzzoff law, that's the law that we cited in our briefs. And more to the point, it's been shown that Lanier could have been liable under the DPPA for knowingly obtaining, using, disclosing information without there being a willful violation of the statute. That is what's meant by potential liability. That was alleged in the complaint. Next, with regard to coverage B and the enumerated claims that are covered, remember you have to read it broadly. They said because the DPPA wasn't listed. Well, it wasn't listed, but the violation of a person's right of privacy was listed. And a person can have a right of privacy that comes out of the common law, or that right can be statutorily conferred upon a person. And the DPPA statutorily conferred the right of people to be protected from others who would use the information from a DMV form and disclose it to other folks. Next, on this, the only thing that was alleged in the underlying lawsuit was obtaining the information. I think one of the Court of Appeals cases, the appellate cases in the Fourth Circuit mentioned it. I would submit to the court that if you want to see what the claim was, you need to look at the amended complaint, not what some appellate court who is trying to interpret North Carolina law says. And the amended complaint in this case in paragraph 127 says this: as a proximate result of defendant's unlawful conduct as described above, and above they talk about the knowing use, knowing obtaining, knowing disclosure, the plaintiff driver sustained actual damages in having to retrieve the mailings addressed to them from the delivery person from his or her entryway or a mail receptacle, or by or by having his or her privacy invaded by disclosure of his or her name or address in connection with a potential need for legal services. So there is a direct allegation in the complaint that the right of privacy has been invaded and a claim is being made for that activity. The last thing I want to say, this court sometimes asks, what happens if we rule for you? What happens if we rule against you? If you rule against Lanier, one, Lanier has to pay her bills and doesn't get reimbursed from Farm Bureau. More to the point, everyone who reads that Court of Appeals opinion and this court's perhaps opinion that comes down is going to say willful and knowing are now the same thing. So all of those situations where there was a distinction in cases from this court, criminal or otherwise, there is no more distinction. What was clear is now murky. More to the point, every time someone does a knowing act, that will become a claim for punitive damage.
Thank you, counsel. I believe your time's expired.
Thank you.